Today we'll talk about custodial interference, protecting your rights and your children. The topic of custodial interference affects a lot of families. Whether you're dealing with it yourself or just looking for more information, I hope you find this information useful. To start, let's define custodial interference. Custodial interference is when one parent interrupts the custody or visitation of another parent without legal grounds. Some examples are refusing to return a child after visitation, hiding a child, or even persuading a child from seeing their other parent. Custodial interference is not only damaging to your children, but it can come with some legal repercussions. So some common examples are refusing to exchange a child, relocating to another city or town without notifying the other parent can be considered custodial interference, negatively influencing your child, so trying to persuade your child not to go for visitation with the other parent. And persuading your child could also include making your child fearful of the other parent. And another is blocking communication, which would mean not allowing your child to contact the other parent if they requested to, or preventing the other parent from contacting your child. Custodial interference is not just a legal issue, it's an emotional one. For the child, this can cause confusion, anxiety, fear, depression, or even feelings of guilt. The child can be left feeling torn between the two parents, which can cause long-term psychological problems. But ultimately, it's the child that suffers the most when custodial interference is used. I'll give you an example. The courts are clear that you cannot block communication between your child and their other parent. As I said previously, this means that you cannot prevent your child from contacting the other parent, and you cannot prevent the parent from contacting the child. Preventing communication may not be the worst thing that you can do. I'll give an example. Perhaps you have a situation where the father is trying to contact the children. And every time that the children get on the phone with the father, the mother makes them put it on speakerphone, and she sits there in a chair across from the children and gives them nasty looks, makes exaggerated responses to things that the father says, maybe sits there and mouths things like, "Your father's a liar," or "Don't believe him," or things of that nature. Or just sitting there with a ticked off look in your face, constantly looking at your watch, just making the children generally feel uncomfortable or fearful. All this parent is doing is causing the child anxiety and potentially getting themselves into a legal difficulty. It's possible that this parent's also bad-mouthing the other parent when they're not on the phone, making negative comments about the parent to the children. If this campaign is successful, the children may refuse to see the other parent, they may become fearful of them, or they may not want to talk to them on the phone anymore because they don't like being put in the position where mom's sitting in the chair staring at them, making comments and making them feel anxious and fearful. The consequences for custodial interference can include fines, losing some custody or all custody of your children, or even jail time. If you are on the receiving end of the custodial interference, you're definitely going to want to start documenting everything that is occurring. You're going to want to keep detailed records of any incidents that occur, the dates, the times, as much information as you can about the phone call or the interaction. You're going to write down anything your child might have said, anything that maybe you see on social media that the other parent has posted, any emails, text messages that you have. All of these things you're going to want to keep. And you're going to want to keep this in some type of a journal so that you can refer back to it, and if necessary, you can turn it over to the court. So you're going to want to be careful of what you record. Make sure you try to keep emotion out of it. Make sure you try to keep any derogatory statements about your spouse within these notes. You just want to be as detailed, though, as possible about what occurred. And the reason you want to do this is because someday you may end up in court and you may have to give examples and explain this information to a judge. And although you may think that you've got a great memory and you're going to remember all of this stuff when you finally get to court, I guarantee you won't. It's a very stressful time, and it's not something that you can anticipate how you're going to react. And also, it looks better if you can provide some type of documentation that shows that over time you were writing these notes at the time that these incidents happened. You don't want to sit down right before you're going into court and start scribbling a bunch of notes and things all in at the same time with the same pen, where everything looks like it was just written right before you got into court. It's better if you have something that can show that over time you were recording all of this information when it was fresh in your mind so that it's accurate information. Other thing you want to do is try to communicate calmly with the other parent. Getting them ticked off at you or starting to get in their face about the things that they're doing may start to break down your communication. Even if you have very little, it's better than nothing. You may want to seek mediation in this instance or possibly some type of co-parent counseling. If the custodial interference violates a court order, don't hesitate to get the authorities involved, especially if it's a situation where the parent was supposed to drop the child off or you were supposed to pick the child up and the child is not there, or the other parent is making excuses for why they're not there. Definitely contact the police. And you're going to want to make sure that you have a paper copy of whatever court orders you have, because they're going to want to see those. They're not going to take your word for it that this is your visitation time. They're going to want to see it. If you don't have it on hand to show them, then it becomes a she said situation and they're not able to do anything about it. And you definitely want to contact your attorney if you have one whenever incidents like this occur, because they can better give you an idea of when it might be a good time to bring this up in court or take a court case forward. Now, I don't want to mislead you to think that one or two incidents of custodial interference is going to have any impact on your custody of your children. Even if you have a whole catalog of incidents of custodial interference or even parental alienation, which I will discuss in another video, that doesn't mean that the courts are going to do anything about it. Although you think that or feel that these incidents are impactful to you and your children, the court may not feel that they're severe enough to actually take any action. And by the time you have a ton of incidents recorded and you're ready to go to court, at that point, the courts could look at it and say, well, these incidents didn't occur very frequently, or they were months apart or years apart, and therefore they don't feel that they were as impactful as you do. But again, the lawyers and the judges are not living your life. They're not living your divorce. They have no idea how impactful these types of activities are to you and your children. So that's why it's so important to document all of the information and not just rely on trying to remember them or spout them out to your lawyer. You definitely want to make sure you keep a record of all of these incidents.